drive so high. Feet on the ground, but I still get by. Rules were made for someone else to try, but not me, not me. They said slow down, son, take your time. But I was born running every stop sign. Sky is the limit, no chance to hold. Sky is the limit, I'm breaking the mold. Sky is the limit, I'm out of control tonight. Every doubt just feeds a flame. Every scar reminds me why I came. I've been broke, I've been blessed, carry faith in an empty chest till now. The stars are down like good old friends, saying, boy, don't stop where the sky just ends. Sky is the limit, no chance to hold. Sky is the limit, I'm breaking the mold. Sky is the limit, I'm out of control tonight. Sky is the limit, no chance to hold. Sky is the limit, I'm breaking the mold. Sky is the limit, I'm out of control tonight. Sky is the limit, no chance to hold. Sky is the limit, I'm breaking the mold. Sky is the limit, I'm out of control tonight.
Welcome to the show. Today is Judge John O'Donnell, and yes, she is a twit. She really thinks that suing Megan Fox is going to work. So Linda, I did what I did to keep this channel safe for now. Everything's still here, it's just not visible to the public. She's a twit. She got Olaf. Oh, I need to get that. I need to get that link. She's really, really funny. Olaf is really, really funny. Some of her stuff is really funny. Actually, you're right. It isn't okay that this is happening. Excuse me. Hold on. Another earthquake. It's not okay that she's doing this. I'm just waiting for YouTube to wake up and do something about it. What, she's not a twit? She's a twit. I hope that no. I just did what I did to protect my channel from being hit. Those videos are in a safe place. So, for Judge John O'Donnell. She's not very smart. Not very smart if she thinks she can do this. Let me fix this. I know she's not going to win. I know she's not going to win. And you know why I know she's not going to win? Because you can't claim damages from a video you claim it under a. So what she's claiming is that the video was under a paywall and people were getting the content from it. Wrong. When you went live, like we are live right now today, okay, we're public. We're out there in the public right now. We are broadcasting on YouTube and we are broadcasting on Rumble. So that's public. You put it under a paywall after your live stream. So she's trying to claim that Megan and all of them were getting her material after it was it was put under a $500 paywall. Nobody in their right mind would pay that kind of money. And she has to prove, and that's another thing too, Linda, she has to prove that there are members in that category. Okay? Yeah, she has to prove that she has to show, when she goes to court, she has to show that if there are any members in that $500 membership group, and there are none, she blew her case right there. But let's get started with Judge O'Donnell. Stupid neighbors playing music.
Helping my sister with the kids and working a lot, so.
Well, whose responsibility is that?
Mine.
Okay. So what are you complaining about?
I'm not.
Yeah, you are. So you mean that you gotta watch your kids and you gotta work?
Well, no, I don't gotta watch my kids. I'm not allowed, I help my sister out with all
How do you
the
help
kids.
your sister?
My nieces and nephews and everything.
How do you help your sister?
Yeah, I watch them all while she goes to work, and then I gotta get a babysitter so I could go to work.
You babysit her kids?
Yeah,
What about your kids?
I have my kids they're there too. I don't babysit them because they're my kids, but and they're my nieces and nephews too. I don't, I just watch them.
So you gotta work, you gotta take care of kids, and so you're tired, right?
Yeah.
Well, welcome to everyday life that everybody has. So, Kim, how long have you been working at the probation department?
13 years now.
Where'd you work before that?
Lake Erie Correctional Institution.
How long were you there?
4 years.
Okay. Did you have kids?
I did.
All right. Did you have to take care of your kids?
I did.
Okay.
Yes.
And you had to work?
I had to work, yes.
Imagine that. So it doesn't sound like the excuse of I'm tired is going to stop. You seem a little bit irritated about being here today,
No.
about answering my questions.
No.
I can't change you. Kim can't change you. Nicole can't change you. If you want to live like a malcontent, then live as a malcontent. If you want to live like a regular person, staying out of jail, then live like a regular person and stay out of jail. Go to work, meet your obligations every day. Or not. I don't care. I don't change what you do. I just clean up the mess that you make. When do you work?
I work, well, I'm starting 6 days a week. There's only 3 of us that work there. My brother full-time, I'm full-time, and then the other guy's part-time because he works another full-time job.
When were you supposed to work in the last 4 days?
Tuesday, Wednesday, and maybe today.
Do they
Might
know
have
where
to
you
work.
are?
Huh?
Do they know where you are?
Yes.
Did you get your license yet?
Not yet.
Why not?
I asked my mom to put me on her SR22 bond, and she told me to wait till the beginning of this year to till her insurance restarted for the whole 6 months. So that's what I was waiting for, because it was cheaper to go on hers instead of getting my own and paying. I have to pay like $400 a month. I'll pay like $234 or something, $243. I think she said it was a month for me to be added on there.
Oof. How much money you make at your job?
I'll be making I'll be salary now, so I think he said $13.50 every 2 weeks
Okay.
since I'll be
Stop.
salary.
Stop spending money on cocaine. You'll have money for insurance.
Yes, sir.
All right, I'm gonna keep you on community control, 4 days, credit for 4, an IOP with Lake Geogga, and follow all the recommendations and everything else I told you to do back on August 20th.
Okay.
Now, get your ass out of jail, get back to work, and meet your obligations
All right. Thank you, sir.
without the cocaine.
I will. Thank you. All right.
Do you want to see them today?
I know. I come right through.
Come see me as soon as you.
Do you remember those offenses?
From what I've been reading about it, yes.
Do you remember them independently of reading about them?
Do you remember them independently from reading about them?
What's that mean?
Do you remember them without reading about it?
I mean, just,
To be honest, do you remember the offenses? Would you remember them if you hadn't read about them?
no.
How long has he been in jail? Since,
I don't remember. I got here like 3 or 4 months ago.
okay, so you were in Lorraine Correctional then, right?
You were in the correctional.
Yes.
Okay. How long is your sentence there?
I go home in May, don't I?
Mm-hmm.
I go home in May, sir.
Okay.
I think it's the end of May sometime.
When did he get there? Do you know?
To Lorraine Correctional? No, I do not know.
I presume it was sometime after February 11th.
Correct. I believe that he was violated by the parole board based on this, not even on this case, a separate issue.
Do you know?
And we conveyed him here for arraignment.
I don't know the exact date, Your Honor. I know he was sentenced to 9 months.
On a violation?
On a violation not pertaining to this case, a different violation.
Oh, okay.
I've been trying to contact his parole officer to get the exact violation. I've not had any success.
All right.
I took.
Are you having overall problems with your memory or not?
That's what my biggest issue is, they're saying.
When's the last time you saw a doctor about this condition?
According to, that's what my issue is with the jail right now. I just went to see the doctor in the jail, I think I told you or my wife. Last week, I went and seen the doctor, and she told me I won't be on the list to go out and see a specialist for 2 or 3 months from now.
Are you going to file a motion to deal with the competency? Because it seems to me that if he's representing to me right now that he's got memory problems to the extent he doesn't know his kids' names, that would be an issue of whether he could, and he doesn't have independent recollection of the offenses. If that's accurate, then that would indicate that he may not have the ability to assist in his defense.
Yes, that was the plan, Your Honor. I just was waiting to see what was happening today prior to filing that competency, but I will get it filed today.
Go ahead.
I understand. I don't want to be in here no more.
Okay.
I'll
Well,
accept what you give me. I don't want to be here no more.
well, I can't give you anything until I find out if you're even competent at this point because of the stroke. So get that filed. We'll try to move this as quickly as we can to make a determination to resolve this thing. Anything else from the state?
Nothing further, Your Honor.
Okay, Nicole or Nicolette, get that thing filed, okay?
Yep, I will. Thank you.
All right.
All rise.
Seated. Mr. Gagrich.
Thank you, Your Honor. Before you today on State versus Emmanuel Silliman, file 25 CR 1682. We're here today for a pretrial. Discuss the matter with Mr. Goldberg, and it appears we have some kind of issue with the portal, which I'll rectify upon my return to the office. Other than that, State of Ohio is prepared to go forward.
What's the offer?
There is no offer at this point, Your Honor.
So it's plea to the indictment?
That we haven't even discussed any kind of a...
Mr. Goldberg?
That's correct, Your Honor. We filed discovery, and I take Mr. Geiger's word that there's some kind of snafu. But we get that discovery, I'll review it quickly with my client, and we will start talking about resolution.
Okay, I'm going to set this case for a jury trial on March 16th at 8 a.m. And then we're going to set another hearing that'll take place March 4th at 8:30 a.m. And that will be the opportunity, Mr. Silman, for you to either accept the offer, whatever it is, or reject the offer. Do you understand that?
Yeah.
If you reject it, then we'll proceed to trial on the 16th. Anything else, Mr. Geigerich?
Nothing, Your Honor. Thank you.
Mr. Goldberg?
No, Your Honor, thank you very much.
All right, we're adjourned.
You know, the only...
How far did you go through school?
10th grade?
Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
Nope.
Did you get a copy of this information?
Yes.
Do you understand you have a right to have your case submitted to the Lake County Grand Jury for them to decide whether or not to indict you?
Yes.
Did you discuss that right with your attorney?
Yes.
Are you going to waive that right?
Yes.
Your Honor, in open court, myself and my client signed the waiver of indictment and passed it to the prosecutor to witness the same.
Here, I have received the waiver of indictment. I witnessed the defendant sign the document in open court. His counsel signed it, and I have signed it.
All right, I'll accept the waiver of indictment. Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk some more to Ms. Novotny, let me know and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have a constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
Nope.
You still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time. I could sentence you to prison, to jail, or to community control.
Yes.
Violating a protection order is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Are you presently on post-release control to the parole authority?
No.
Do you understand that if a prison term is imposed in this case, you may have to serve a period of post-release control as part of this sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, a parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. You understand that?
Yes.
If that violation is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to occur, the maximum prison sentence would be the greater of 12 months at the time left under post-release control. Do you understand that?
Yes.
You understand if a prison term is imposed, you are eligible for judicial release.
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. You understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
Nope.
Has anybody promised you what I will sentence you to? Do not have to follow the sentencing recommendation of either the prosecutor or your lawyer.
Yes.
Have you had enough time to talk to Ms. Novotny before pleading guilty to everything about your case and answered all of your questions?
Yes. Yes.
Have you been threatened or coerced in any way to plead guilty, knowingly and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
Nope.
Ms. Cutts, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on December 10th of 2025, shortly after 2 a.m., Wickliffe Police Department officers were dispatched to the Plaza Motel on Euclid Avenue in Wickliffe, Lake County, Ohio, to speak with Jennifer Chinchar regarding a protection order she had against Christopher Hensley, the defendant. On December 2nd of 2025, Ms. Chinchar had filed for and was granted an ex parte civil stalking protection order under revised code 2903.214 in Lake County Court of Common Pleas 25 CS 002232. Defendant was served with that ex parte protection order as well as with the final hearing date. He was served on December 3rd of 2025 by personal service. The final hearing was scheduled for December 9th of 2025. It did go forward. The defendant did not appear. The protection order was granted on December 10th of 2025 to be in place for a year. When the officers arrived on December 10th, 2025 and spoke with Jennifer Chinchar, they learned that the defendant had been calling and texting her since about 1:40 a.m. He was calling and texting, requesting information about whether she went to court that day or not, which was regarding the final hearing of the protection order. She either spoke to him or he left voice messages, so she was able to hear that it was in fact his voice, as well as he was referring to something he would specifically know. While the officers were there, the defendant called. Ms. Chinchar answered the call on speakerphone so that the officers could hear. He identified himself, indicating that it was in fact Chris, and he was asking her about if she went to court. She indicated, as well as law enforcement, that he is not to be in contact with her. These calls were about 10 texts and 6 calls from between 1:40 a.m. and 3:08 p.m. throughout the day, even after the police left. The defendant does have a prior conviction for violating protection order under 2919-27 out of the Willoughby Municipal Court in case number 22 CRB 02392, dated November 1st of 2022. It was the same victim in that case, and that all of this occurring in Lake County, Ohio, and that would have been the state's evidence. Thank you.
Thank you. Ms. Novotny, anything to add to those facts?
No, Your Honor.
Mr. Hensley, did you hear what Ms. Cutt said? The facts would show if the case went to trial.
Wait, what'd you say?
Did you hear Ms. Cutt?
Yeah.
The case went to trial.
Yes.
Are those facts true?
Yeah,
What is your plea to violating a protection order, a felony 5?
guilty.
Ms. Novotny?
Remember this document. Sign date. Today is 1/15/26. Your Honor, in open court, myself and my client signed the written plea of guilty paperwork and passed it to the prosecutor to witness the same.
Your Honor, proceed the written plea of guilty and judgment entry. A witness from the bench signed the document of the court. This also signed it and I signed it.
Mr. Hensley, is this your signature on the written plea of guilty?
Yes,
Did you sign it voluntarily?
yes,
Do you want me to accept your written plea of guilty?
yes.
Accept the written plea of guilty. Defendant was present. Ms. Novotny advised of all of its rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty.
Yes,
Finding it to be knowing, intelligent, and voluntary, I will accept his plea of guilty and find him guilty of violating a protection order of felony 5 and refer this for an updated pre-sentence report. Sentencing will be February 13 at 11 a.m. Ms. Novotny.
Your Honor, we would like the court to consider a bond modification, specifically if the court would be inclined to consider an own recognizance bond for Mr. Hensley. Mr. Hensley informs me that he would reside at 28439 Evergreen Drive in Willoughby Hills. He lives there with his mother, who is 92 years old, and he is the primary caregiver for her. Helps her with everyday functions and living, does housework for around her and maintenance. He also helps maintenance along with the neighbors on his street that are elderly with regard to anything revolving the house. Your Honor, he also works, from my understanding, for Best Asphalt. He's been there on and off for 15 years. I know recently he's had some medical issues with intestine surgery. Previously in June 2025 he had it, in September of 2025 as well for a follow-up. And he is seeking medical attention as well. I know he's been having problems and complications for where that surgery has been occurred. Your Honor, we're just asking for any type of leniency when it comes to bond today.
Ms.
Thank
Cutts?
you.
Your Honor, when this agreement was made, there was no talk of changing bonds. We were not anticipating a request for this. However, we do feel that it would be inappropriate the defendant continued to call and violate this protection order for the entire day. He did admit when he was arrested by the police that he had been served with the protection order and that he knew he was not to be contacting her. He disregarded that in Willoughby Municipal Court. He was told that he was only to make phone calls to his lawyer from the jail. He has been making phone calls to other individuals as well, so he did not listen to what that judge said either. He does have a criminal history that includes 2 prior prison terms on 5 cases. All of those cases were before Your Honor, and he was sent to prison in 2021 for possession of drugs, 2 different cases, F5s, as well as an F5 theft in a 3rd case. And then he was sent back to prison in 2023 by this court on 2 different cases. One in this court, an F5 possession of drugs, and a Cuyahoga County F5 possession of drugs. He got out in 2024. Ms. Chinchar has indicated that there have been other protection orders that he has violated. We know that from his prior as well. So based on his history, how he handled this matter, we would ask that his bond at a minimum remain where it is, if not be increased or revoked.
All right, I'm going to revoke the bond. Anything else?
No, Your Honor.
Oh, Your Honor, the victim impact statement also be ordered.
Victim impact statement.
So you'll be back on February 13th at 11.
Don't have a bond, don't get out of
You
this?
don't have a bond, no.
The first relates to a notice of deposition for a representative of defendant AECom. That deposition was noticed in late December. Defendant's counsel indicated that it had some objections and asked for a meet and confer. We did do the meet and confer. As a result of the meet and confer, I attempted to address many, but not all, of the issues raised by AECom's counsel. I believe at that time we were still on an impasse at 9 of the 31 categories requested in that deposition notice. However, for the remainder, I did make some attempts based on our discussion to modify some of those. Amended notice of deposition was issued the following day. We received late yesterday new objections to the amended notice. I believe now the amended notice, by the way, eliminated a couple of categories, so there were 29 distinct topics.
Which 9 remain outstanding?
The 9 that remain outstanding are presently, after the latest round of objections.
Well, before you tell me that, which 2 were eliminated from the original 31?
The 2 that were eliminated are all documents produced by AECom, which was originally number 26. That's been eliminated entirely. And I'm sorry, I did a compare red line, so I'm looking at that. The last one originally was 31, which was AECom's discovery responses. I eliminated those in their entirety.
Okay, so all but 9 have been agreed upon? Is that what you said earlier?
No, we were at an impasse at that point after the meet and confer, except with respect to 9 of those. After I revised and narrowed the scope of some of them, we are now at an impasse at apparently 12 of the 29 categories.
So you were at 9, you revised it, now you're at 12.
Well, to be fair, after the meet and confer, I revised them. He had to go back to his client to, consult with them.
Okay.
And after that, there were still some that they refused to produce witnesses on. So that's that initial issue.
Okay.
The second issue is I noticed a fact witness employee of defendant AECOM, Vikram Gautam. He is a geotechnical engineer on the project based on discovery.
You say he was on the project. They say he was not on the project. He had nothing to do with the project.
Yeah. Well, Your Honor, I didn't know what that until they produced documents that imply or suggest that, in fact, he was specifically consulted about the use of the shale fill material when it was being proposed. Now, I understand, based on our meet and confer, that his intention is to say that he doesn't remember that. Well, that's fine, if that's his answer, but I believe I'm entitled to cross-examine him on that.
Okay.
So that's with respect to the project. He was also consulted later when AECOM was investigating what the issue was. He was consulted at that time too. Again, the documents indicate that. So that's another issue I think I'm entitled to talk to him about. I believe I'm also entitled to talk to him about his general knowledge, understanding, experience, and expertise as a geotechnical engineer with respect to this use of this material in general.
If he was involved in the project?
Whether,
Or if one of those two factors, either when the problems arose initially, and you raised that to AECOM, if he then reviewed things, so is it one of those two hooks that he would be able to talk about that in general? Or
Correct.
just as a guy who knows this stuff, or
That's
may or may
right.
not know? Okay, is one of those two hooks, right?
that's right, Your Honor.
Okay.
It's plaintiff's position that AECOM sold this project to my client on using its vast knowledge and expertise in every specialty. And therefore, I think that we are entitled to explore, whether or not they did that. We know that actually they did, and what that knowledge and expertise was, and why they didn't use it in this case, apparently.
Okay.
So that is the second issue. The third issue is just the general order and scheduling of depositions. No one had noticed depositions in this case before I did so in December. I noticed those and requested that they be provided in a particular order based on plaintiff's strategy in this case. I believe I'm entitled to do that. Approximately a week later, defendant AECOM issued its own deposition notices, which is fine. I don't object to any of those, including the 30B5 categories that they gave me, which are very similar to the ones they're objecting to in mine, but my clients don't have anything to hide. But given this dispute with respect to these two issues, I don't believe they should be able to take the depositions that they requested of mine because they manufactured a discovery dispute, so they could go first. I think it's common practice, and if everybody's being honest, if you notice depositions first, you get your witnesses first. That's just the way it goes. And so, until we can, agree on the depositions that I've asked to take, I don't think I should have to produce my witnesses. Now, I did offer to schedule them all, including mine, in the order that I requested off of the bat, and then deal with these discovery disputes. And if we could get them resolved, we'd have them calendared and scheduled. Nobody seemed to want to do that, and so we were apparently at an impasse on that issue. From the plaintiff's perspective, those are the three issues with respect to discovery.
Go ahead.
Thank you, Your Honor. Dan Heyman for ACOM. Addressing the three issues, starting with the 30B notice, and we've presented, as requested by the court, our position in pretty good detail, generally into the specific requests. And I don't think it's accurate to say after we had our meet and confer, we were down to 9. We got a revised notice, and we did make some progress. Some there's agreed to be limited. We got the revised notice, I believe, last Thursday. As I told Christine, we would review and get back to her. She unilaterally said, here's the revised notice, we're now down to 9. But in any event, I think we're at about 13. But as we've indicated, Judge, first of all, this is the first deposition they want to take. Okay, so of a 30B, there's been no depositions, which is going to require us to educate someone on this project before the benefit of any depositions, including our former employees. All our employees on this project that happened 8 years ago are no longer with us. So, it's likely, instead of being able to point to their deposition testimony, we're now going to have to schedule meetings, et cetera. And some of these, as you've seen, that just the sheer volume is impossible.
Hold on. So you've indicated Stahl, Lachina, Wenzel, and Harvey, right?
I'm sorry, Stahl, Lanchina.
Stahl, Lanchina, Christy Wenzel, and Brad Harvey.
That's correct. There's been no, and they're no longer with the company.
Right.
And there's been no request yet for Wenzel or Hartman. But we have been in contact with Stahl and Lanchina. They work for other companies now. And as I explained to plaintiff's counsel last week, I can't in good conscience ask these people to call in and schedule time off of their current jobs on a tentative basis with no idea if this deposition's happening. We're prepared to present those people, but if plaintiff insists that we have to have a 30B5, assuming we can agree on some categories, that's going to take some time because we have an obligation to educate someone on this. And there's been, our client alone, I think, produced almost 500,000 pages of documents. We're getting close to 1 million pages of documents in this case. We're talking about incredible breadth, especially what they've asked for, and putting aside just the ones that are incredibly broad with respect to this project. We have 3 or 4 of the 12 that are in dispute. I have 13, but 12 or 13 that are in dispute that want us to put up a witness who has global knowledge of all the projects that AECOM has done, global knowledge with respect to certain issues. And so that's just, I don't know how you even begin to do that.
The issue relates to the fill, right?
Correct.
That's what we're talking about, the fill.
Correct. There's fill on every project, Judge.
I know that. So the issue in this case, the main issue seems to be the fill.
Correct.
The shale.
Correct.
Okay. So
but how are we about to, find out, from the scope of what they're asking for? It could be a project in California, it could be a project in Beijing, it could be, and how do we even begin?
Okay, let's quit playing around. Let's take out the list
Okay.
of 1 through 29 and go through it. What's the first one?
First one, Your Honor, is AECOM's knowledge, evaluation, and decision-making regarding the suitability, risks, recommendation, and use of pyritic shale spoil excavated from the Northeast Ohio Regional Sewer District project as engineered fill supporting interior building slabs of the YMCA School District and Senior Center.
Okay, go ahead.
We've agreed to produce a witness.
I'm sorry,
that involves this project.
I'm trying to find your latest objection.
No, let's go, I'm looking at the original list of 31.
Okay.
That's what I have in front of you.
Would you like, Your Honor, for me just to go over the ones that AECOM says they will not produce
Well, I'd like to
witnesses
see a
for?
copy of it, so I'm looking at it as your, all I have is the original that was filed with these emails.
I think it would be helpful, Judge, if you had the amended notice.
Judge, I do have a clean copy of the amended.
Yeah, I do as well.
And do you have our responses? Would you like our
This
responses too?
This is our responses.
Okay.
So that's the what Christine said is the amended in your responses?
Yeah,
That's
I have
correct, Your
the
Honor.
amended, yes,
That's the
yeah.
current status.
Okay. Thanks.
The court should have an electronic copy of this as well from our position that was submitted yesterday.
I did also, Your Honor, at Maria's request yesterday, provide her a red-lined version so you can see how they were changed from the first notice to the amended notice, and I can give you that if you think it's useful.
All right, well, number one on the amended list, there's an agreement.
Correct. So I will move, Your Honor, to number 2,
Okay.
which there is, AECom has indicated in its latest objection that it cannot produce a witness. That is AECom's knowledge and experience nationwide and globally with projects using shale or shale-containing materials as engineered fill, regarding suitability risks, recommendations, and use of shale or shale-containing materials as engineered fill for the project where AECom has the noted knowledge and experience.
Okay.
And again, Your Honor, plaintiff's position is AECom regularly markets and sells itself as a global leader with expertise in all of these areas. And in fact,
So what is it you're looking for?
I'm looking to know what they know and understand about using shale fill material on construction projects.
Judge, if I can put a little perspective on this. Every building in Northeast Ohio's got shale in the fill. And if you look at the expert reports, it is a very detailed analysis, and we don't have to get into it now. But the notion that there's a green light, red light on shale fill is just nonsense. I mean, we'd all be living in tents in Ohio if that was the case. There's shale everywhere. So this is so broad. This, I don't know how many tens of thousands of projects, and how do we even begin to do that? And they're all different because they all have geotechnical.
Is it your position that shale shouldn't be used as a fill? And shouldn't have been used as a fill in this project?
That's right.
Okay. What does the contract say?
The contract has the specification for engineered fill, does not permit the use of clay, which shale is specified as is classified technical terms as.
So I presume you're going to have an expert that says that this was the improper fill to be used to take out whatever was excavated.
Yes, Your Honor. And his expert says that, and everybody's expert says that.
Okay, so
That's not the issue. The issue is I believe I'm entitled to tell the story to the jury about why AECom, knowing and understanding, being the global leaders in construction that they are, decided to propose to my client to use this material that is plainly and commonly understood as to be improper underneath the building.
But it wasn't permitted to be used, is what you're saying, by contract and by all the experts, right?
That's right.
Okay.
Not our expert, Your Honor.
Okay, well.
And but that is the issue. And so it has nothing to do with our global knowledge.
I know it's the issue.
It has nothing to do with our global knowledge. And they didn't, we may market ourselves that way, they didn't hire that services from us. We had no designer or engineer, we were the construction manager. They hired the architect, who, like every project, has a geotechnical engineer that they hired, who tested this specific material and told us it was okay. So is there an issue?
Or didn't test it and say it was okay, one or the other?
They
'Cause
absolutely tested it.
Okay, and they say you didn't test it.
No, we
So-
did
But
it.
anyway, see, we can sit here from now until the summertime when it's scheduled for trial and talk about this shit, but what I'm interested in knowing is getting the depositions done, because the expert reports were to be filed June 2nd, I think it was, okay? And the remaining by September. Now that's been moved, done. Fact discovery was done. But apparently,
Oh, Your Honor, I believe at the regional case management conference, due to the case, there was no fact discovery set.
I know there was no,
Yeah.
I
Correct,
presume
that
I presume that
expert-
you wanted to do written discussion in advance of taking depositions,
That part was,
okay, not positions. So let's try to get off the ground and stop discussing, I brought up the contract, so that, but I want to get the, so you think you should be able to have somebody who be that has knowledge of and all the representations they've made. They made the represent.
they made it on their website, and they made
Okay.
it in the response to the
Okay.
request for proposal for this project, where they say, as a full-service
So
company.
so you believe that it's proved that they hold themselves out as action?
That's right, Your Honor.
Okay.
I have no idea.
Who do they produce for something? How about the president of ACOM?
The president of ACOM's not gonna have knowledge of everything.
Okay.
Well, that's
I
what,
don't-
globally.
The
Listen,
United States.
Oh, great.
your point is they hold themselves to construction, okay? And because shale was used, either pursuant to the contract, that's a bullshit claim that they made. Otherwise, all right, what's that really got to do with this? Isn't this a case of whether the use clay/shale? Isn't that the point?
Ultimately, but again, I think I'm entitled, and because I believe the facts are clear, including their geotechnical engineer that they consulted with. using this
Consulted with
material.
either during the project or after
During-
Guyama, or whatever, that guy.
I believe when I get to, they shouldn't have used this material. So, the jury's going to question, Your Honor, why did they do that? And I think I'm entitled to tell the full story. And part of that story is that they didn't bother to either use their expertise that they promised us that they would use, and that I think is part of the standard of care that is an express provision in their contract, to use their expertise.
The contract either calls for them, allows them to use shale clay, or not use shale clay, right? The contract.
Your Honor, shale clay was not originally specified to be used. It came about as a change on the project due to the discovery of unsuitable soils during the site work.
Well, I mean, is it unusual to find unsuitable soils in site work?
It is not unusual, Your Honor, and therefore the contract included not the type of material to be used, but a unit price. So AECOM was only able to charge our client by contractual agreement before they knew that they had to bring in 10,000 plus cubic yards of this stuff, that they were only going to charge $25 a cubic yard. They were limited to that by contract. Their subcontractor apparently had this, and when it bid the project, bid very low for that unit price, which probably helped them win that contract. And so they had to use something that wasn't going to eat into their profit margins. And so they used this shale. And I want to tell the jury about how AECOM fully well knows that it shouldn't have been used, but they disregarded that because they just cared about making as much money as they could.
So it was not prohibited by the contract?
Your Honor, it was
Shale-
prohibited by the contract.
Okay. You told me the only restriction was the unit price or whatever had to be used as the fill.
No, Your Honor, the specifications have a general specification for the types of material that are acceptable and unacceptable by their general classification. By their general classification, the material is unacceptable. Nevertheless, the construction manager recommended it, and the architect and its geotechnical consultant approved it.
Okay, I'm not going to let you, 2 is out. 3.
Okay, 3 is AECom's knowledge, expertise nationwide and globally regarding the known risks and consequences of using expansive material as engineered fill, including but not limited to AECom's knowledge and experience regarding when unsuitable fill material must be sent or rejected or sent to a landfill.
Similar objection, Your Honor. I don't know how we even begin to present a witness on that.
Who hired ATC?
The architect TDA, we did not hold that contract. And by the way, ATC is the one who, in real time, when the decision was made about using this fill, tested it twice and reported the results. TDA reported to us that it was acceptable. But I don't want to get into all the merits like we've been going. I want to focus on this, Your Honor.
So do I, but I had that question because you keep saying we weren't the geotechnical engineer.
They didn't hire us for
on
geotechnical
the
service.
project.
Sorry, Your Honor. That's correct. And our contract expressly says we are not responsible for the architect's scope, which included the geotechnical engineer. So we may market ourselves that way, and we certainly have that capability because it's a big company, but they didn't hire us for that. They hired us for what's in our contract, which is to be the construction manager.
And so whose job was it to provide the geotechnical engineer so that the specs could be drawn and the contract fulfilled?
I'm sorry, it was the architect hired the geotechnical engineer who, like any project, started with the geotechnical engineering report before design's even done, talks about what kind of fill can be used, et cetera. Then, of course, we get the specifications, which is what we're bound to. But none of that we didn't have anything to do with developing those specs. That was the design professional and their geotechnical engineer. Is there an issue of fact as to whether or not we met the spec? Yes, that's what this case is. It's that simple, Your Honor. And all this other stuff about telling our story wants to distract from what happened here and why.
So who was responsible for determining what fill went back in the hole?
Your Honor, the construction the entire construction and design team. So the construction manager was
who had by contract, who had the approval? When decisions are to be made, such as this one, we're excavating however many cubic feet, what's going back in, whose job is it to approve or disapprove of that?
Your Honor, I believe it is both the architect's job and the construction manager's job.
That's what the contract says?
Yes, and the contract has a specific provision that says if the construction manager recommends a material or product that it warrants to the owner that that material is fit for the specific purpose.
Your Honor,
Your Honor, when there was a discussion about what fill to use, the architect did not propose shale or any other material. The construction manager proposed the shale material.
Okay. So going back to number one, that everybody agrees on.
correct.
Who's going to be produced for that?
I don't have a body here, but because it's limited to this project, we can educate someone. It's going to be someone who wasn't on the project, most likely, because there's none left. But we, as we can do and have an obligation to do under Rule 30b-5, we'll educate someone as best we can with the records. We'll try to put them in touch with the people who are on the project if we can, but they don't want
As to the decision-making regarding the suitability?
It's all in the records, Judge, and we'll have someone that will have reviewed and educated themselves on the records.
Okay, so somebody will have reviewed the suitability and the risks and the recommendation of the use of the shale?
That's correct, Your Honor, the spec section is very clear, by the way, when you have unsuitable soils, the architect in consultation.
I don't care about that, okay? You're going to produce somebody that answers her questions about the suitability of this shale being used as the fill, correct?
Everything in here, the knowledge, evaluation.
I'm just focusing on the shale.
Yes, Your Honor.
Okay, and so there's somebody that kind of infers to me there's somebody within AECom that looked at the suitability of shale. Okay? And so she's going to ask, well, what did you review? Who did you get this from? I got it from Joe Schmo.
That's correct.
She can go depose Joe Schmo.
You're correct, that's, which is actually a third-party defendant, GLC, who was our site contractor. But, Your Honor, I mean, we did object to this, although we produced a witness, just to make it clear. We didn't make the decision.
I thought we agreed on number one.
We didn't make the decision, but we'll have someone who can talk about everyone who did and all the
I
records.
thought we agreed on number one.
Correct, Your Honor.
Okay. Then what are you objecting to?
Well, I'm sorry, I thought you were asking who we were gonna produce for number one.
I was asking that, okay? But whoever you produce for number one is going to be able to talk about the recommendation of and use of shale.
That was made by the architect, and it's.
I don't care who.
Okay, yes.
So
yes, Your
that's
Honor.
going to point her in a
Yeah,
direction that
yes.
it was Joe Schmo, okay? And then she can go and depose that person, right?
Yes, Your Honor.
So what's the problem with that?
No problem with number one, Your Honor.
I know there's no problem with number one, but you want to talk about their knowledge of, in their representation that they know all this stuff.
Yep.
And part of what you're going to find out is their recommendation and use of shale. And that's going to point you in a direction of somebody at ACOM or within ACOM or who ACOM consulted that says shale's good for this. So why isn't that enough? Why doesn't that give you the same thing you want by the worldwide investigation here?
I think, again, Your Honor, I mean, if you believe the interpretation of that is broad enough to encompass that, then I'm fine with that.
That's what I believe.
Okay. And we're in agreement that I can ask about those matters within the
Well, they've
scope of
already
number
agreed that
one.
you can ask about those matters.
Number one.
Right.
Correct, Your Honor.
Okay.
Not number two, which is out, and there's similar ones after it. We're not gonna have a witness who's gonna talk about our experience at every project that ever used shale.
I just said that. We just
Okay.
covered that.
Okay, well, I think Plaintiff's counsel said as long as I can do that on number one. I just want to be clear, Your Honor. Thank you.
Okay,
Okay.
Your Honor, so just to move this along, I'm gonna agree to remove 2, I'll remove 3. 5. Okay. Let's move on to a different issue. Number 6, AECOM's knowledge, understanding, compliance, performance, and breaches of the contract with the plaintiff for the project that is the subject of this lawsuit. AECOM has responded that it will only produce a witness who can authenticate the CM at-risk form executed by AECOM. And their knowledge and understanding of that is contained in the plain language. Somebody that says, yeah, this is the contract. But
That's
not
our-
talk about what they did, didn't do, should have done. And just by the way, Your Honor, they asked me almost the exact same question for my witness.
Which we discussed our meet and confer, and I said if you want to narrow it, we will. I've asked for a meet and confer on their 30B5 because both parties have an obligation to conduct one, and I haven't had it yet.
I don't have any objections.
Okay, well, good, that's, thank you.
I thought I said that at the
We'll
beginning.
expect dates then for those witnesses. Your Honor, knowledge and understanding is in this contract is thousands of pages. It's a construction contract. Compliance, performance, and breaches, again, are we going to put a witness who's going to talk about everything we did that's documented in 500,000 pages of records? Or are we going to focus on what's at issue, which is number one, which we've agreed to do? So it's not.
Well, part of what their complaint is when they brought the first heaving of concrete or cracking in the walls, they said, well, you guys are warranting this work, so come and look at it. And according to the plaintiff, you said, well, we don't know nothing about nothing. Everything's good.
Not accurate, Your Honor. There were years of the parties, and well after this project was done, well after punch list, where we were involved. Architect was driving that ship, by the way, which you would expect, because it's a geotech issue. But nonetheless, there are other specific categories in here with particularity, like what did you do to investigate, that we're agreeing. You know, warranty claims, we're agreeing. But this general, give us someone who can talk about everything you did on the contract and all our allegations of breach, is again, just not within reasonable particularity required by the rules. It's basically the whole case. Put someone up who can testify about anything I want to ask on this case.
If it's limited to the issues in this case, I don't know why I wouldn't be able to ask about those things. And I don't know why you wouldn't be able to produce a witness to do that. We all know what the issues in the case are. I'm not going to ask about some obscure section of the contract that doesn't have anything to do with this case, of which there are many. I think we all know what the issues are.
So you're talking about number 6 as it relates to the fill and building envelope issues?
Yes, Your Honor.
That's, again, number 1 is the fill, which we talked about. There are specific things, to your point on investigation, as we go through this, I can point to them. We agree to that. If you tell us particularly what you want, we have the ability to prepare a witness. To prepare a witness on anything about this contract, and certainly we're not going to prepare and present a witness who's going to interpret the written contract and give some kind of analysis, is overly broad, and it doesn't meet the rule requirements of particularity. Some of these others do, and we've agreed to present a witness. But this is a catch-all about anything I want to ask, they better be ready for it. How do I prepare a witness for that?
As it relates to the fill and the building envelope, right?
Yes, Your Honor, and I can add those words if it, but
That would seem to satisfy Dan, wouldn't it?
Correct, Your Honor.
Okay.
And just to be clear, Your Honor, I do think I'm entitled to question them on their understanding of what particular parts of the contract pertinent to those issues mean.
Under what basis? I mean, it's a written contract. It says what it says. That's for the lawyers and the court to determine.
Your Honor, they act in accordance with what they understand the contract to mean. So I think I'm entitled to ask.
So give me an example of that.
I'm entitled to ask him what he thinks it means when they warrant that they're recommending a material, and what he thinks recommending a material means. Because they're taking the position that they never recommended the material. Well, I'd like to know what their position is on that.
On whether they had an obligation to warrant the material?
Correct.
Or recommend the material?
To recommend the material and the warranty associated with that recommendation.
Whether we recommend the material
As one example.
is an issue of fact, which we can keep going, is number 1.
Well, so why can't she do fact discovery?
She's going to ask a lay witness whether or not you satisfied this warranty obligation, or doesn't this warranty, or even a legal argument what the contract.
I think she just said she's going to ask whether it was your obligation to recommend or not recommend.
That's number 1. We'll have a witness on that. But this, as written, number 6 is, if we want to limit it to the fill and building envelope, that's okay. But to have a lay witness who's going to be interpreting contract provisions is not appropriate.
Well,
she could ask if we know or not we satisfied it, what we did. But that's what, I think she's made it clear what she wants to do.
I want to know what their understanding of that provision is. And others.
Well,
that
they
relate
either
to that.
had an obligation to recommend, or they didn't have an obligation to recommend, right?
Well, I don't know, Your Honor, about the obligation, but
Under the contract.
What the contract says is that if they recommend, then they must provide this warranty.
Okay.
Our position is, in fact, they recommended it, and they provided the
So
warranty.
your hope is to get somebody up there to interpret the contract and say, yeah, it was our obligation to recommend?
No, Your Honor, I want to ask them what they understood that provision to mean.
Okay, for what though?
Because they're taking a specific interpretation of that. And so I want to know what the company's position is on that interpretation. I know what the lawyers say. I want to hear what the witness says.
That is the company's position.
What did you say?
Thanks, but I'd like to hear a
what the
witness
lawyer-
under oath cross-examined as to that position and not their lawyer.
So don't you want to find out from the fact witness whether ACOM recommended use of the shale? Isn't that the issue?
Yes, Your Honor.
So what difference where's the relevance of some guy saying, well, my understanding of this provision is that we were to recommend, or my understanding of this provision is we were not to recommend? What does it matter? The issue is whether they recommended or didn't recommend.
That's right, Your Honor, and there's a dispute about what recommending means. And so I think that I'm entitled to question him on what the company's understanding and position is.
What about what they actually did? What the fact that establishing the fact, not establishing what their theory is of what this means or doesn't mean.
Yes, both, Your Honor. I
Well,
agree.
but why is one relevant? One is definitely relevant. One I'm not sure is relevant.
Well, Your Honor, here's how I understand their position to be based on what I've seen so far in the case and not having taken any depositions. Notwithstanding the fact that their project manager sent an email saying, you can use this material for this price that you
Okay.
are
So-
obligated to pay, that is not a recommendation.
Okay, so you're going to depose that person, whoever wrote that email. And you're
I
gonna
am, Your
say-
Honor, but here's what I'm trying to avoid. They're going to take the position, if it's convenient for them, that whatever he says doesn't bind the company because he's no longer an employee and he's
Well,
not
he
the
was at the
30B5.
time.
I understand.
Okay, so what does that matter that he's no longer?
Well, that's
You
why,
wouldn't- I mean, that would be a ridiculous position to take, wouldn't it? We're not responsible, even though he worked for us and said this,
Yes,
because he
Your
no longer works for us. That would be ridiculous,
Yes,
wouldn't
Your
it?
Honor, and again,
Okay.
number one is knowledge of hazardous decision-making regarding suitability risk recommendation.
I know what number one says.
We're producing on
Okay,
that. That's
but-
the issue.
But you know who that person is that said you can use this material at this price to Great Lakes Crushing, right?
I know, Your
Because there's an
Honor,
email that says that.
I know based on that email. I don't know what communications happened internally at AECom to get to that email where they recommended the use of that material.
Okay, so don't you ask the guy who wrote that email, why did you say this? Where do you get that information from? Well, I get it from this guy over here. Well, then I'll go depose this guy over here.
Yes, Your Honor, I understand, but again, the reason that we do 30B5 corporate rep depositions is because they're technically the only ones who can bind the company to those statements. So if I then present their former employee as saying something, they can say, well, that is not our corporate representative, he cannot bind us to that position.
Well,
Made worse by the fact that they clearly fired him because he messed up his project.
We're certainly not going to stand in front of a jury and say that, Your Honor, but we've agreed to produce that individual as well. But again, we're focused on the 30B5 and we'll produce someone who's going to basically parrot what he's going to say, if that's what they want.
Yeah, that's what
But
we
that,
want.
again, does not get into giving legal opinions on what a contract means, which is not relevant. That's for the lawyers in the court to determine.
I'm not asking anybody for their opinion in
Well,
this, I'm asking for their understanding,
Well, isn't that their opinion? Isn't it the understanding their opinion?
not necessarily.
Well, it certainly isn't a fact, is it?
It's a
This
fact.
thing means this.
It's a fact based on that individuals act based on their understanding
Well,
of things.
it's
And
their-
so I want to know what their
And-
understanding is.
And their understanding is going to be what's written on the paper, Your Honor.
Well, that's what you say. He can say that,
Okay,
and
so
I can
so who would this
cross-examine him.
person be? Who do you imagine this person would be?
Your Honor, I don't know. It could be one of, I don't know how many people who worked on this project, were responsible for this project.
I think
Or
you-
somebody who wasn't, and that they
I-
educate and give them that
I certainly think you
information.
can depose somebody who has, with regard to the contract, as with regard to the contract issue of the fill in the envelope, their testimony on whether they complied with the terms of the contract or not.
Okay, so is the only issue then the word understanding? I'll take that out.
And if you, well, again, Your Honor, performance of the contract and breach, I mean, that's so broad. I mean, how do
I'm going to go out on a limb here and say, if you produce somebody to talk about whether AECom complied with the terms of the contract as it relates to the fill and the building envelope, they're going to say, of course we did.
Most likely, Your Honor.
Well, and then what are you going to say? Well, And that, are you,
Again, Your Honor, I have agreed that adding the word, limiting it to the issues in this case, which are the fill and the building envelope issue, is sufficient from my perspective. And further, I will eliminate the word understanding.
Your Honor, number 17.
They want to just say, yeah, this is the contract and nothing more. I don't think that's acceptable.
Your Honor, number 17 is any warranty claims for or relating to any water infiltration issues and floor slab issues for the project is the subject of this lawsuit would agree to produce a witness. When they describe with particularity factual issues that they want a person on, you agree to produce them. But these general, just to have someone talk about your performance under the contract is not the required reasonable particularity that the rules require. Same thing with the contract. They have number 18, AECOM's contractual warranty obligations for the project that's subject to lawsuit. We've agreed to produce. Okay, in the thousands, if not tens of thousands of pages of this contract, you now, with reasonable particularity, have told us what we have to prepare a witness on. We can do that. But these broad, just, catch-all, so I can play a gotcha game
okay,
with an unprepared witness.
you have, of the 29, you have either 16 or 17 you've agreed to, right?
I believe that's correct.
You said 13 you don't, you said 12.
I thought it was 12 when I counted.
Okay, so let's do it this way. Tell me the 12 you've agreed to.
Oh,
The
so it should be
17 that you've agreed to.
Sure. Here.
1, 4, 6, 7.
Well, I don't think 6, based on this.
Well, we
objection.
say we had a qualifier, so, all right. So 8, 9, 10, 11, 12, 13, 15, 16, 17, 18, about 20,
Okay.
22, 23, 25. I believe that's it.
And you have one more that you thought was agreed to?
No, Your Honor, I have mismarked it on my copy. I think that what Mr. Hayman said is accurate.
Okay, so 2 and 3 are out.
I think I also agreed to remove something else.
I think 5 was another
5.
one of the national and global.
Yep.
Okay, well, so let's go to 14. Are you talking about written communication?
Any.
Huh?
I'm talking about any communications, Your Honor. Now, I understand nobody's going to know every conversation that anybody have. That's why the standard is whatever is reasonably available. But they're obligated to go and find out what communications there were that go beyond the scope of the documents. And if there's nothing available, then there's nothing available.
Your Honor, I don't know how we determine all representations that were made on this project at this point, other than written, which are going to be thousands, most likely. I've seen enough of them. And, former employees who were prepared to present, and they can talk about what representations they made. But again, the breadth of this, I don't believe meets the requirement of the rule of reasonable particularity. If there were certain representations that you could identify for us that we could educate someone on, because that's what we have to do, because the people who worked on this are no longer with the company, we can do that, but I don't know where to begin on this. I mean, do we give them, you know, tens of thousands of emails that have been produced in this case? Start going through, and I mean, it's unworkable. It's not reasonable particularity is required under the rules, and it's unduly burdensome. You know, again, the rules, not only 30B, but civil rules in general, does require that you weigh that. And if there's other means that do not, you know, require us to go through all of this, where you can depose the people who are on the project, you can ask them about their written communications, you can ask about their oral communications. But if you want us to educate a 30B5 witness on something as broad as this, it's a Herculean task, and we don't think it meets the balance that the rules require with respect to undue burden.
So you know who was working on this thing for ACOM, right? Working on this project?
I believe I know some of them.
Well, there was 4, you read them at the beginning of the
Were
day.
those the only 4 people from ACOM that were in the capacity as the construction manager on this contract?
That's correct, Your Honor, and one of the third-party defendants, Green Space, had some individuals that were sub-consultant to us. And Plaintiff's counsel has asked for 2 of them, and we've said, yes, we'll produce those 2 former witnesses, or excuse me, former employees, who were the ones who were having these, as everybody knows from the records, these communications.
Okay, so you know you're going to depose those 4 people, I would assume.
I'm going to depose at least 2 of them presently. I haven't issued everybody who I'm going to depose, but Your Honor, I think the issue from our perspective is they're taking the position that is the owner's fault that this material went into the ground, among other things. And so I think I'm entitled to question a witness to get the company's knowledge of what you told the owner about this material.
The company knowledge is gone, Your Honor. We'll recreate it if we have to.
What do you mean the company knowledge is gone?
The employees who wrote the emails are no longer with us.
I know that. Okay,
but we will educate someone.
Who were those individuals?
John.
No. What was their position within?
John LaCagna was the project manager on South High School. This contract is for 3 schools. South High School is what we're here for. Dave Stahl was the project executive. Christy Wenzel, I believe, was an engineer who basically just is, documenting stuff. And the other person I don't recall exactly, but the other 2 that they haven't asked for really were not that involved. The records show, but they're free to explore if they want with them.
Okay. So if, let's say that whoever the first guy is,
John LaCagna.
LaCagna says, yeah, I told Great Lakes Crushing to put that shitty shale in the ground. Does that not bind the company? Is that your position?
Oh, Your Honor, if they want to say that if they want to agree that all of Mr. Landocino's statements bind the company, that's acceptable to me.
And if that, why wouldn't they bind the company?
Well, I think, Your Honor,
as a construction,
as far as binding the company, the 30B5 deposition is you're entitled to introduce it at trial as evidence, regardless of any witness availability. So that's what it is, which is why we have a lot of these things like legal understanding. This is a game of gotcha. Quite frankly, most of the stuff should be interrogatories or RFAs, but they're not, and they want us to put up a witness who's going to slip up and say, yeah, we agree that's what that contract interpretation means, and say, we've now bound the company and we're going to read that to the jury. It's all fine and good, Your Honor, but we have the right to insist that they meet the rules, which is why the rule requires reasonable particularity, because of the uniqueness of a 30B5 and the obligation for us to prepare someone and the fact that it's admissible evidence. We have the right and opportunity, number one, to insist that they have reasonable particularity balanced with undue burden and hardship, especially when there's other ways to get this evidence. I mean, whether or not Mr. Lakina binds the testimony, his testimony is what it is. He's going to either say the same thing at trial or they're going to impeach him. You know, so again, there needs to be reasonable particularity so we can produce a witness. Now, normally, Your Honor, we'd have fact depositions, and when our 30B-5 occurred, and they said, we want the representations, we're going to say, our witness is going to say, read Mr. Lakina's deposition, pages 50 to 80. But they want this to go first, fine, but that's going to put a burden on us, and we need reasonable particularity so we can produce someone else to say, good job.
All right, go to 19. Okay, so claims are made when things start going wrong. Is there a record of who at ACOM investigated any warranty claims?
There is, Your Honor.
Who's that?
It's primarily Mr. Lakina and Mr. Stahl, and in conjunction with the Green Space construction management people. But again, this is you know, I believe I have the year right. The school was completed in 2019. These issues, at least formally, were presented to us, I think, in 2021. If I have, you know, almost 2 years after the building was open. Mr. Stahl, at least Mr. Stahl, I don't remember Mr. Lakina, I believe he did too, re-engaged.
Were they gone at that point?
No, they were not, Your Honor. They left shortly thereafter. We responded. There's other provisions in here where they say all notices and response to notice. We said, fine, and we'll produce someone on that, you know. But the investigation was those two individuals who, of course, they can depose them. They left both left in early 2022. So at that point, it was basically lawyers. Green Space, I believe, still had someone who was involved. They were meeting regularly with the architect, with the school. The architect was doing a whole bunch of analysis. They were doing floor scans and all this stuff. This went on for years, basically, at least 2 years, where the architect was driving that train and deciding what to do and they hired a consultant to do investigation, et cetera. So, you know, after 2022, when Mr. Lakina and Mr. Stahl left, ACOP did have an individual who had nothing, when they requested a meeting, they had an individual who had nothing to do with the project and he would go out, but then it really became the lawyers and their experts, so it's really getting into, but again, it's not like we had an investigation over a weekend. It is an incredibly broad topic with incredible breadth that went on for years before this lawsuit was filed.
Okay, so do you know who investigated these warranty claims?
I know Mr. Lakina and Mr. Stahl was involved. I don't know Mr. Gotham, apparently, but I don't know beyond that. But again, Your Honor, I don't know why I wouldn't be able to ask about how they investigated the warranty claims that they breached. Because and if he wants to say only Mr. Stahl and Mr. Lakina know, that's fine. But then he should agree that their deposition testimony binds the company. And it's not overbroad, because if your position is that these are the only two guys that were involved, well, guess what? They can talk to whoever you want from the company, get their knowledge and understanding, and then testify on behalf of the company. It's not broad. That's what the case is about.
If Your Honor, if I may, if we were to do this like most of these proceed, and we had these categories, and we're going to take Mr. Lakina's deposition, and this is very typical and usual, you'd say, okay, we're gonna now do Mr. LaKeenya's individual deposition, and we're gonna now, but he's now gonna be on categories 4 and 5. You can now depose him as a 30B5 witness. They won't do that because they want us to have a 30B5 before we do Mr. LaKeenya. Am I gonna get Mr. LaKeenya to sit for 2 depositions? I'll be, hard enough to get him to sit for 1, scheduling time off his job. So let's do them together if that's the case. It may very well that we can get him to be one of these, but we can't, if we want to insist on a 30B5 first, it's a problem. I mean, the 3 individuals that plaintiff said investigated are 3 individuals that have asked for their deposition. We'll get to Mr. Godham in a minute, but we've agreed to produce them, but we have a clear understanding and ask the court's guidance for some of the various reasons we've talked about, global knowledge, et cetera. But they'll have the opportunity to depose those 3 people. But if they want a 30B5 on something this broad, it is going to take a long time to educate someone on that, rather than just ask the people who actually did it.
All right, 21. Isn't that the same? It's the same as 19, except for floor slab.
It's the same objection, Your Honor, but that's correct. It's basically, again, I'm talking about thousands of representations, probably.
All right, 24, go to 24.
Similar objection, Your Honor. We don't believe this is with reasonable particularity. They've got all whatever written internal communications there are, but again, we're talking about hundreds of thousands of emails that have been produced in this case. And this is a very broad word that makes it difficult, if not impossible, to prepare a 30B5 witness, as opposed to deposing the people who are actually writing the communications.
Your Honor, if I might, it seems like what Mr. Heyman is saying is that if there are individuals who are involved, then companies are not obligated to produce witnesses pursuant to 30B5 notices. If that is in fact the law, then please cite that to me so that I can, consider it, and I will, remove my thing. But that is absolutely not the law. There are individual fact witnesses and there are corporate representatives. Only corporate representatives bind the company. Again, if he wants to take the position that those individuals are their corporate representatives, that's fine. He can pick whoever he wants. It seems to me that relieving the burden that he's talking about is to use those people as his representative. Then he should just do that. He can pick whoever he wants, whether they work there or don't work there. It doesn't matter.
Even if I pick a Mr. LaKeenya or Mr. Stahl, or probably some of these categories would be several people, they're going to be our 30B5. Now I got to have them prepared for more than just what they know. Fine. We have not taken the position that they're not entitled to take a 30B5. We have taken the position that they got to meet the rule requirement that you specify with reasonable particularity so we can produce a witness. I think we've already seen, Judge, this 30B5, the way with the scope that they're envisioning, is going to take a week. I mean, there is undue burden and hardship to be balanced when you cannot say, produce a 30B5 witness to answer anything I want to ask in this case. That's not the rule. And that's what they're trying to do with all of these broad categories. And as you see, just so they're sure, they just keep repeating a lot of them in different forms, so that in essence they have us educate a witness who can talk about anything to do with the case. That's not a proper 30B5 purpose.
All right, so you have around 26 through 29 that are in dispute, correct?
Correct, Your Honor.
Okay. So I'll consider those that are still in dispute and rule on those. Okay. Now what about this?
Thank you, Your Honor.
This guy that is Godham. What about Godham?
We've agreed to produce him, Your Honor, for deposition. As I told plaintiff's counsel, I believe he's going to say, I have no recollection of ever working on this project or discussing with them during the project. That's fine if they want to do that. You know, there's about 6 in the sea of thousands. There's, I don't know, 5 or 6 emails where they're trying to schedule a meeting with him. But that's it. There's no record that it ever occurred or that it ever did it. But nonetheless, that's fine. They can depose him on that. But they've made it clear in their submissions to the court, but what they want to do is turn him into a geotechnical expert and start asking him all of his opinions about geotechnical items with respect to shale fill, which is irrelevant to whether or not we met the spec. And they're trying to turn him into a expert witness who's not been designated as such. And they know, because I've been out there with Christine and Mr. Godham on at least 2 occasions, that after the lawsuit was filed, we as attorneys have used him as a consulting expert, which is absolutely privileged under the rules of work product. So, you know, we will not let him testify to any of that privileged material. But if they want to take his deposition and hear him say, you know, and who knows, and maybe they'll throw something from him or he'll recall something, but to say that he doesn't have any recollection work on the project, we'll produce some. But we're not going to let them get expert opinions out of him, which again are not relevant to whether or not we met the specification. We were not the geotechnical engineer on this project.
Your Honor, I don't intend to depose him to seek his opinion. I want to know what he knows about this type of material and its use in similar applications.
How is
Why-
that?
And I'm not even going to take the position that what he says is true or not.
Well,
But I want to know.
so what does it matter what he thinks? What does it matter what he thinks is shale in these kind of projects? He either had some input on it, or he didn't.
Yeah, Your Honor, I think one of the reasons why it is very relevant is because, again, if they have institutional knowledge of these things, they represent and market themselves as bringing that institutional knowledge to all of their products, and in this specific case, made that representation to the client. It matters, and it matters because there's a consequential damages waiver in this contract, except if they acted with gross negligence or willful misconduct. And so if they're talking to a guy who knows something about this material and why it shouldn't be used, and he either didn't tell them or told them something that was accurate or told them something inaccurate, and they proceeded to use all of that stuff anyway, it goes to the issue of their gross negligence and willful misconduct.
Okay. Well, I guess what you're going to have to do is tell me when you do your deposition at Gowden, okay? And I'll sit at my desk and stare at my phone and wait for it to ring.
Okay.
Okay?
I don't intend, Your Honor, to ask him anything about work he's done, the Thompson Hind firm, anything he's communicated with them, or anything they've communicated with the dozens of in-house counsel they have on this case.
I'm just, I'm struggling to find out how, what he says other than as it relates to this project is relevant. But you can ask it, you can object, and then you can call me when you can't agree.
Thank you, Your Honor.
Okay, what about this ordering and scheduling? The first attempt to schedule depositions was December, mid-December?
Yes, Your Honor.
I guess the first question is why is that?
Your Honor, from the plaintiff's perspective, it was a large and substantial task for everyone to gather and produce the extraordinarily large quantity of documents in this case.
Okay.
It was a very big task for the parties to, or at least again speaking from the plaintiff's perspective, to get their experts' reports completed. And then, Your Honor, at least the plaintiff spent a substantial amount of time preparing for the mediation, which
I bet that went over like a lead balloon between the parties, right?
not even
It was not successful, Your Honor. And
It sounds like it was a disaster.
yes.
What did it last, like 5 minutes?
It's always a
No.
disaster if it's not successful, Your Honor.
No, well, sometimes it's
It was
successful
2
in
days.
that parties narrow some issues and get closer together so that it can work eventually.
It was 2 days. And if I could just speak to that, couple of issues. Document production has been an issue, and we've been trying to work with Plans Council on that with their production for a long time now. We had 40,000, I think, additional emails from the YMCA produced in November, right before the mediation. I think just this week, based on our meeting confers to try to get the school district, because there's some glaring deficiencies, we got another roughly 30,000. So that's not been done. I've also been trying to get verified interrogatory responses on things as simple as itemized damages, which we don't have yet. But I do believe that the mediation, we didn't get the expert report until June. We didn't get the building envelope expert report until September. The parties did spend, I think, substantial time selecting a mediator during 2025 and scheduling it. I think we had our first call with him in August. There was a lot of meetings, and at the very first meeting with the mediator, there was a discussion about what do we need to do to get this case ready for a meaningful mediation. And there was a discussion about, do we do a bunch of depositions, or do we do things like get some expert reports in the mediation setting, because they're not due yet, and we still don't have the third-party defendant expert reports, so that we can do that. So all the parties, I think, did focus on the mediation, at least the latter part, once the plaintiff's expert reports were in September on that process. So I do think that that was a conscious decision that I can't speak for everyone, but that the parties collectively made was the best use of our time at that point.
I agree.
Okay. So besides your 30B5 and the individual, how many other individuals do you anticipate deposing?
Your Honor, thus far I have noticed, I believe, 3 individuals, 2 former AECOM employees. I believe the project manager for Great Lakes Crushing, which was the site contractor that brought in and used the fill, as well as the 30B5 of Great Lakes Crushing. Quite frankly, I was waiting to see what information I got there and where else that was going to point me. Mr. Heyman has requested the deposition of Jeff Henderson from TDA.
So you've indicated about 6 different people right now, right?
Presently, yes, that I have noticed.
Okay. Dan?
I believe we've asked for 8, and I've actually, because the party's not here, ATC's not in the case, but I've reached out to their counsel and asked for one of their employees. And quite frankly, Your Honor, I mean, mine include their experts, which is another issue I think that not just me but other parties want to discuss is the case schedule. And we have a February report deadline, and March 1 summary judgment deadline, which we currently have, is why I asked for their experts. If there's a change to that, I mean, the experts can obviously wait, but those are the ones that I
So 9
essential,
9 or so?
that I would like to have at least before the dispositive motion is due. There's going to be a few more. I mean, I think the other parties, there'll probably be another dozen at least, I would think. Any other parties have feelings on that?
George?
Well,
You've been very patient.
representing the architect TDA, Mr. Heyman has noticed the deposition of main architect of TDA on this project. Christine did not notice any. So what TDA intends to do for depositions would really depend upon what's going on with plaintiff and AECOM. But I mean, we produced an expert on behalf of TDA. ATC is not
Steve?
You guys gotta find another route to come and go.
Yeah, either they're gonna be traveling down 84 a long ways,
Right,
or 20.
right. I told them, get on the river, come all the way down. And I said, either that, or then cut over to 2. I said, that's all you can do.
Kind of interject things based on our last meeting. I want to make sure that you understand that you are, unless you're testifying, you're not to talk. You can talk to Mr. Matthews confidentially, of course. But I don't want to see any talking out of turn or comments or things like that. You understand that?
Yes, I do.
Okay. All right. Everybody ready to go?
Yes, sir.
I'm going to go get them and then come and get me.
All rise. Yeah. What did we do without him? Right. Gentlemen, make sure your cell phones are turned off, please. All rise.
Seated, please. Good morning, ladies and gentlemen. I want to welcome everybody to the Lake County Courthouse this morning. My name is John O'Donnell. I will preside throughout this trial. With us is Carl DeFranco, the Lake County Clerk of Courts. He's going to swear you in. If you would stand, please raise your right hand and respond. I will. Go ahead.
Do you solemnly swear or affirm that you will truly and fully answer all questions put to you by the court or counsel in this case, and this you do as you shall answer unto God? Thank you.
Thank you, Mr. DeFranco. I know this is your first opportunity for jury service, and you watched a video this morning that tells you a little bit about what to expect for your service as a juror, but I'm going to give you a little bit more of an introduction to jury service before we get started. Service as a juror is an important civic duty. Trial by jury is one of the most valuable rights that we all possess in the United States, and that preservation of that right is strengthened by your response in being here this morning. Now, I recognize that each of you are making some sacrifice by being present today, and I know it represents some inconvenience to each of you, but I also believe you will recognize that jury service is necessary. The jury system that we use is a system that lets everyday people decide issues that affect other everyday people. So the sacrifice being made by you is a sacrifice necessary to ensure that we continue the jury system. Now, I recognize that some of you may be feeling a bit nervous or stressed at the thought of having to serve as a juror. Those are common feelings often expressed by jurors that have never served before. Many people think they don't know what jury duty entails or that they're capable of performing the duties of a juror, and I want to assure everybody that you're more than capable of performing the duties of a juror. Now, it's my hope that your service as a juror or a prospective juror will be an interesting and rewarding experience, and those selected who hear the case after the trial is done, when I talk to jurors after jury trials, they almost universally indicate that they enjoyed their service and are interested in coming back again. So once again, I want to thank you for being here this morning. You've been summoned as prospective jurors in the criminal case entitled State of Ohio versus Toussaint Burrell. Mr. Burrell is the defendant in this case, meaning that he is charged with committing a criminal offense. Specifically, the indictment alleges in count 1 that on or about May 30, 2025 in the city of Painesville, Lake County, Ohio, Toussaint Burrell did knowingly obtain, possess, or use cocaine or a compound mixture, preparation, or substance containing cocaine, a Schedule II controlled substance. The amount of cocaine did not equal or exceed 5 grams. It was alleged to be 2.71 grams. In count 2, the defendant is charged with illegal conveyance of drugs of abuse under the grounds of a specified governmental facility. The allegation is on or about the 30th day of May 2025 in the city of Painesville, Lake County, Ohio, Toussaint Burrell did knowingly convey or attempt to convey under the grounds of a detention facility or of an institution, office, or building or other place that is under the control of the Department of Mental Health and Addiction Services, the Department of Disabilities, the Department of Youth Services, or the Department of Rehabilitation and Correction. A drug of abuse is defined as in 3719.011 of the revised code. The indictment filed in this case, which sets forth the charges read to you, is not evidence. It is used to inform Mr. Burrell that he has been charged with the offenses. The fact that it was filed may not be considered for any other purpose. Mr. Burrell has pled not guilty to the charges. A plea of not guilty is a denial of the charges and puts in issue all the essential elements of each offense. The state of Ohio and Mr. Burrell are entitled to jurors who approach this case with open minds until such time as a verdict is reached. It would be unfair and improper for you to decide this case based only on part of the evidence or without hearing the court's instructions and the arguments of counsel. Do not jump to conclusions on the basis of the first or the last argument or the first or last evidence presented to you. In addition, jurors must be free as humanly possible from bias, prejudice, or sympathy and not influenced by preconceived ideas either as to the facts or to the law. You will receive the facts from the witness stand. Instructions as to the law will be given to you by the court, and it is your sworn duty to accept and apply the instructions that are given to you. I want to begin explaining the procedure by which some of you will be selected to serve as jurors in this case. As I said, each of you are undoubtedly qualified to serve as a juror. However, there could be something that could disqualify you in this particular case or under the particular specific facts and issues presented in this case. So we're going to go through a process whereby I ask you questions and the attorneys ask you questions. This part of the trial is called voir dire. It's an opportunity for the court and the attorneys to ask you questions in an attempt to learn a little bit about your background to make sure that you can be fair and impartial jurors in this case. These questions are not designed to pry into your personal affairs, but to discover if you have any knowledge of the case or any preconceived opinion which you cannot set aside, or if you have had any experience in your personal or family life that would cause you to favor either party. These questions are necessary to assure each party has a fair jury. I will ask you some questions first as a group. If you have a response, raise your hand and I'll call on you. Every time an individual speaks, the juror number must be stated by either the individual juror or whoever's doing the questioning. This is necessary so we have a record of who is talking at the time. After I've asked my questions, the attorneys will ask questions as well. And these questions, once again, are not intended to be offensive or to pry, but to find out that you can be fair and impartial in this case. Now, I'm sure that you would understand that if a person has a preconceived idea as to how this case should come out or some other interest in this case, that person would not be able to serve as a juror. That person would be excused for what is called good cause. After we are done questioning you, you will be excused. I'll meet with counsel out of your presence, at which time 13 individuals will be chosen to serve as jurors in this case. One of the 13 will be the alternate, and that person will not be identified until just before deliberations begin. Now, it's important that you be open and honest as this questioning goes on. If you are not open and honest, we can't get necessarily a fair and impartial jury. So we need you to be open and honest. If when you're being questioned by either me or one of the attorneys, if there's something you don't want to talk about in front of the whole panel, let me know that, and we'll talk individually at that time. Now, seated directly in front of me, representing the state of Ohio, our Assistant Lake County Prosecuting Attorneys, Abigail Bell and Emily Contour. Would you introduce yourselves, please?
Good morning, my name is Abigail Bell. Good morning, I'm Emily Contour. We have at trial table with us Deputy Justin Nevison of the Lake County Sheriff's Office.
And seated at the other table is Attorney James Matthews. Mr. Matthews, introduce yourself and your client, please.
Good morning, everyone. My name is Jim Matthews. This is my client, Toussaint Perot.
Thank you. Stan Shadowin is our bailiff. It's his responsibility to keep you together and not to permit you to talk to any person or allow any person to communicate with you during the trial. Kathy Miller is our court reporter. She's responsible for recording and taking down everything that is said in court. It's very important that the witnesses, the jurors, and the lawyers speak clearly and loudly enough for Ms. Miller to hear them. And because people have a tendency to nod in response to a question, you're occasionally going to hear me remind you that you got to verbalize your answer so she can take that down. Now, those who participate in a trial must do so in accordance with established rules. This applies to the witnesses, the lawyers, the judge, and the jurors. The lawyers present the evidence through the questioning of witnesses, which must be done according to the rules. The judge enforces the rules and determines what evidence may be admitted. At times during the trial, a lawyer may make an objection to a question asked by another lawyer or to an answer by a witness. This simply means the lawyer is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the objections or my ruling on the objections. These simply relate to legal questions that I must determine and should not influence your thinking. As jurors, you will be the sole judges of the facts, the credibility or believability of the witnesses, and the weight to be given to the evidence. Later, the court will furnish the law which you will apply to these facts. It is your sworn duty to accept the law as it is given to you by the court. Once the jury is selected, the procedure for the trial is as follows. First, the state will outline in an opening statement what they expect their evidence will show. The defense may then, but need not make an opening statement. These opening statements are not evidence. They are a preview of the claims of each party designed to assist you to follow the evidence as it is presented to you. Then the state offers evidence to support its claim. The defendant may then present evidence but is not required to do so. If the defense does offer evidence, then the state may offer rebuttal evidence. The trial concludes with the instructions of law and the arguments of counsel. You would then deliberate on your verdict. A criminal case begins with the filing of an indictment. The indictment informs the defendant he has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The plea of not guilty is a denial of the charge and puts in issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The burden of proof is on the state of Ohio to prove the facts necessary for its case beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you of his guilt beyond a reasonable doubt of every essential element of the offenses charged in the indictment. Reasonable doubt is present when, after you have carefully considered and compared all the evidence, you cannot say you are firmly convinced of the truth of the charge. Reasonable doubt is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Evidence is all the testimony received from the witnesses, the exhibits admitted during the trial, facts agreed to by counsel, and any facts the court requires you to accept as true. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he or she testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of mankind. Direct evidence and circumstantial evidence are of equal weight. The evidence does not include the indictment or the opening statements or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. To weigh the evidence, or you may apply the test of truthfulness which you apply in your daily lives. These tests may include, but are not limited to, the appearance of each witness upon the stand, the reasonableness of the testimony, the opportunity to see, hear, and know the things concerning which they testified, the accuracy of memory, frankness or lack of it, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you may assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because they were under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of a defendant is to be weighed by the same rules that apply to other witnesses if the defendant takes a stand and testifies. The defendant has a constitutional right to not testify at trial. If the defendant chooses not to testify, you shall not consider that decision for any purpose. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of an issue. Rather, the final test in judging evidence would be the force and the weight of the evidence regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. The court instructs you not to converse with the attorneys, parties, or witnesses during the trial. Likewise, the participants of the trial must not converse with you, and in fact, they are ordered not to talk to you until after the case has concluded. If anyone should attempt to discuss the case with you, report that incident to me or the bailiff immediately. Do not investigate or attempt to obtain additional information about this case outside of the courtroom. It is improper for any of you to attempt to do so. You are instructed not to read, view, or listen to any report in any media on the subject of this trial and do not permit anyone to read or comment upon them in your presence. Such reports may be complete and inaccurate. You may only consider and decide this case upon the evidence received at the trial. If you acquire any information from an outside source, you must report it. If you realize during the course of the trial you have personal knowledge of any facts in this case, you must report that to the bailiff immediately. Now, as I said, I'm going to ask you questions first, and if you have a response to that question, please raise your hand and we'll talk a little bit more about it. First question that I have of you, does anybody know any of the three attorneys in this case? Anybody know the officer or Mr. Burrell? Anybody know me? Number 21, how do you know me?
A little bit.
Okay. Have we met?
I just know you from when you were councilman and stuff.
Okay. Was I a good councilman or a bad councilman? No comment, huh? All right. Would that, if you're selected to serve, would that influence you in any way?
No.
Okay. Anybody else? All right. Do any of the potential jurors know each other?
I do.
Okay, now, I'm going to ask you who that is, but you got to tell me juror numbers, okay? Who do you know?
I believe it's number 10, John Manor.
Can't use names.
Oh, I'm sorry.
That's all right.
Number 10, sorry.
All right, how do you know number 10?
His wife and I worked together several years ago, and we kept in touch on it.
Okay, when's the last time you had any contact with either number 10 or his wife?
I honestly can't say, it's been some time.
Okay. And if you're selected to serve, and juror number 10 is selected to serve, let's say that you went back there to deliberate, and you thought it should come out one way based on the evidence and the law, and he thought the other way. Would that impact your relationship such as it is going forward?
No, sir, I don't believe so.
If he gave his argument as to why he thought you were wrong, would you listen to his argument?
Yes, sir.
Would you consider what he says?
Yes, sir.
All right. And if you still disagreed, would you stick to your guns?
Yes, I believe
All
so.
right. Okay, number 10, same question to you. When's the last time you would have seen number 2, do you think?
I can't remember, Your Honor.
Okay.
It's been quite some time. I've been divorced from my ex-wife for 20 years, so.
Okay. So would that, the existence of
I
that?
apologize, Judge, it's number 14, I'm sorry.
Oh, okay.
The number's wrong. My apologies. Sorry, sir.
It's all right.
All right. Okay, so it's been a while since you've seen
Yes.
14.
I looked at
All
the
right.
numbers wrong, my apologies.
Okay,
My
so-
memory's not very good, I guess.
All right, so 14, tell me the last time you had any interaction with juror number 2.
Got to be like 10 plus years ago.
Okay. I asked her a bunch of questions about what would happen in deliberations if you guys disagreed. Are your answers any different?
No, sir.
All right. You would listen to her argument?
Sure.
You would consider her arguments?
Yes.
All right. And if you disagreed, you would stay with what you believe?
Absolutely.
Okay, thank you. Anybody else know any other potential jurors? I read you the allegations that are contained in the indictment. Does that ring a bell to anybody? All right. Now, has anybody had any prior jury service? And by that I mean, has anybody actually served, gone through this process, been picked and served as a juror? Okay, let's start with your number, please. Number 24, tell me about your prior jury service.
It was 2021, I think, downtown in the courts. It was during COVID, and it was also a drug weapons case.
Was it, so it was in common pleas court down at the Justice Center? Or was it federal court?
Federal.
Federal court, okay.
Yes.
And so you deliberate on a verdict?
Yes.
All right, did that jury reach a conclusion?
Yes.
All right. Anything about your service in that case that would impact your ability to serve as a juror in this case?
I don't think so.
All right, now, during that case, obviously the facts were different than they're going to be in this case. And the instructions of, do you remember the instructions of law you were given? I'm sure it was a thrill a minute, but do you remember them still? Okay. If you're selected to serve and you're sitting there and you're listening to my instructions and you think, well, that's not what the last guy said 5 years ago, I don't think he's right, would you discount what you knew about it, what you thought about it, what you heard back then, and consider only the law that I give you?
Oh, yes.
Okay. Any problem doing that at all? All right. Okay, some other hands went up back there. What, your number, sir, way in the back?
36,
All right. And when did you serve?
October of 24,
And where was that?
here, kind of your court, but upstairs,
Okay, was that a criminal case or a civil case?
our criminal case.
And did that jury reach a verdict?
Yes, it did.
Okay. Anything about your service in that trial that would impact you from serving here?
No.
Okay. Would you be able to set aside the instructions you got and the facts you found in that case, and consider only this case on the facts and the law that I give you?
Yes, sir.
All right. And I thought there were more hands up than that. Number 33, go ahead.
It was a drug-related case in in Lake County Court, and it was back in the late 1980s.
Okay. What do you remember about that case?
We did come to conclusion, we convicted the individual, and it was very interesting.
Okay. Did you enjoy your jury service?
Yes, there was lots of bickering and arguing and lots of swearing.
Oh. Not by you, I take it. All right, so if you're seated in this case, you've heard the questions that I've asked the others. Would you set aside your knowledge of whatever drug laws existed at that time and the state of the law and follow my instructions?
Yes.
Okay. Anybody else? Okay. Has anybody had any prior legal training of any sort, meaning as a law enforcement or things like a paralegal or schooling, things like that? Your number, please?
27,
And tell me about what legal training you've had.
worked for law firms in Cleveland,
In what capacity?
secretary, paralegal, certificates, and associate's degree from Western,
All right. And how long did you perform that function?
probably 20 years.
And are you still doing that?
Yeah,
When did you stop doing that?
about 10 years ago.
Did you perform any in that job anything in the criminal law?
No.
Okay. Would you, if you're selected here, and you remember at least from training, not necessarily from employment, but from training, something different than what you think should be going on here or what the instructions are, would you set that aside and consider this case only on the facts that you find in the law that I give you?
Yes, sir.
Would you have any trouble at all doing that?
No.
Okay. Anybody else? Number 9, go ahead.
I went to college for a short period of time for criminal justice.
And how long ago was that?
2009, 2010.
Okay. Anything about that experience that would prevent you from listening to these facts and following the law here?
No.
Okay. Anybody else? Number 1, go ahead.
I took a criminal intelligence course in college.
And how long ago was that?
About a year ago, year and a half ago.
Is there anything with regard to that class that you think would interfere with your ability to be fair to both sides here?
I think so.
Okay. If you're chosen and you deliberate and you remember something from that course that just doesn't kind of mesh with what you hear in this case, the evidence or the law, would you discount that and decide this case based only on the evidence you hear and the law you receive?
I may bring it up, I'm not sure.
Okay.
During deliberation.
All right. Well, if you understand that the only evidence you can consider is what you hear from the witness stand and what exhibits you see. That's all you could consider in this case. Okay. Would you commit to doing that?
Yes, Your Honor.
Okay. Anybody else? Number 5, go ahead.
Every 2 years, I have to take law, like certification for my nursing license. I don't know if it pertains to this.
When's the last time you did that?
Last October.
Did it involve anything having to do with criminal law? Okay. And once again, I just asked gentleman number 1 the same question. Will you make sure that you confine your decision based upon the evidence you hear and the law that I give you?
Yes.
Okay. Anybody else? Number 6, go ahead.
I have the same, I have a 2-year continuing education credit of Ohio law pertaining to nursing practice.
Okay. Anything about that that would interfere with you being fair and impartial to both sides here? Okay, anybody else? Number 23, go ahead.
The same for me.
A lot of nurses here today, huh? I hope nobody's getting sick out there. Anything different from 5 or 6?
No, sir.
Okay. Anybody else? And, okay. 34? Okay. Same answer as them? All right. All right. Any other nurses in the crowd? All right. Anybody else with regard to that subject area? All right. Does anybody, and I'll kind of lump all these things together, anybody have any ethical, moral, religious, philosophical views that would prevent them from serving as a juror in this case? Okay. Now, it's my expectation, in talking to the attorneys before we got started here, that you will likely hear all the evidence, all the witnesses, and all the exhibits by the end of today. So this trial is expected to last today and maybe into tomorrow. Now, other than everybody's got work and family obligations, things of that nature, is there anything that prevents, beyond those things, anything that prevents anybody from sitting here and hearing this case for, let's just call it at the outside, probably a day and a half? Okay. Does anybody have any physical problems that would prevent them from sitting as a juror in this case? Any back problems, things of that nature? All right. 21, go ahead.
Yeah, I've had about 4 back surgeries, and the last one was in 24. And sometimes it bothers me to sit for a while or stand for a while.
Okay. Now, we usually, we will take breaks usually between an hour and 45, or an hour and a half, an hour 45, somewhere in there. We'll always get a 15-minute break. Would that prevent you from sitting for periods of that long?
No, that would be fine.
Okay. And if say an hour in, your back's starting to bother you sitting down, you can also just stand up until you become more comfortable. Okay. All right. Anybody else? Now, has anybody, as you've been sitting here since about 8:20, formed any opinions about this trial and how it should come out? Okay. Now, as I said, it's the duty of the jury to decide whether or not the defendant is guilty of the crimes charged in the indictment. If he is found guilty, it becomes my duty to determine what sentence is imposed, and I make this decision with the benefit of other information that is not relevant for the purpose of you guys as fact finders, but it's other background information that I would utilize in fashioning a sentence. Does anyone think they cannot perform their duty in determining whether or not the defendant is guilty or not guilty of these charges without thinking about what may happen if he's found guilty? In other words, can you put any potential sentence out of your mind since it's out of your purview? Anybody have a problem doing that? Okay. All right, in a minute here, I'm going to turn it over to the state, the prosecutors, to begin questioning you. Counsel for the state will inquire first, followed by counsel for the defendant. I want to remind you what they say or what they do is not evidence. Evidence is all the testimony received from the witnesses and the exhibits admitted during the trial, any facts agreed to by counsel, and any fact which I require you to accept as true, since it is your duty to decide this case solely on the evidence as is later defined for you. You must not consider as evidence any statement or act of any attorney made during the trial, including during voir dire. Ms. Bell?
Thank you, Your Honor. Good morning. Can everyone see me, hear me, talking loud enough? Let me know, raise your hand, I'll project or move closer. So as the judge already said, I'm Abigail Bell. Together with Ms. Contour, we represent the state of Ohio. We work for the Lake County Prosecutor's Office under Mr. Charles Colson. We have Deputy Nevison here with us. I want to thank you all for coming out on this extremely cold morning, right? Coldest of the year. Being here bright and early on a Tuesday morning. I know that took rearranging of your schedules, and we really do appreciate it. Okay, I'm going to go through the witnesses that we expect to bring here today, and just let me know if you know these people. Lieutenant Mario Eldridge, Ramon Mercado, Gavin Ellinger, Garrett Mason, Sergeant William Anderson, and J. Zachary Dawson. So voir dire is the time for us to get to know a little bit about you, and it's actually the only time during this case that we can talk to you. So the rest of the trial, we can't speak. I know that we're not trying to be rude. If you hold the door open for me and I don't say thank you, I can't. I appreciate it, but I'm not being rude. So this purpose of voir dire is so we can determine who will be a good juror for this specific case. So we ask that you be open and honest. There are no wrong answers. And our goal here is to select a jury who will be fair and impartial to both sides. And I might ask you some personal questions. Again, I'm not, wanting to pry or embarrass you. We just want to see who can be fair and impartial, and you can always ask to answer that question in private. There's nothing wrong with that. So as you sit here today, does anyone feel an allegiance with one table versus the other? Okay, we're all coming in on an even ground, even footing. And the defendant is charged with possession of cocaine. And the judge is going to give you the specific definition that makes up that charge. Based on hearing the charge alone, is there anyone that feels like they cannot sit as a juror? Number 30?
We have one question for you. Why am I the only person here of color?
So it's picked based on voter registry, so it's just whoever is registered to vote in Lake County.
Well, let me give you a little bit better explanation of that. Every year, there's an inventory of registered voters in Lake County. And so this is the second panel that we've had. First panel that we've had, you're in your third week. So everybody here, your name was drawn, and I then begin to select jurors or to get a panel of jurors based on the first one all the way down. I think there's over 100,000, maybe 120,000 registered in Lake County. So you're on a list of 1 to 120,000, and the order that you're selected at random is the order that you're brought in. So that's how the juror pools are drawn. Now, for instance, you're the only one here out of 36. I had a trial, I think 3 years ago, on a civil trial where we have only 8 jurors, where 3 of the individuals were black. So it just, sometimes we get a better mix, sometimes we don't, but everything is a random, and you're brought in the order that you're in. Okay?
That being said, being open and honest, as you put it, I do not feel this is fair.
Okay.
At all.
Well, we could have, I guess, I understand what your statement. We could have a discussion as to how jurors are drawn, but there's two ways. There's 2 ways that different counties draw different jurors. Some do it, well, actually 3 ways. The way we do it, by voter registration. There are some that do it simply by motor vehicle registration. And the problem with that generally is that people move. So you get a lot of people that are summoned to appear that live in this case, they would live in Geauga or Cuyahoga or Ashtabula. So that doesn't seem very effective, or there's a combination of both. But that's how we do it, and that's the explanation I can give you. Okay? All right, Ms. Bell?
Thank you, Judge. All right. So moving to, well, does anyone, just hearing possession of cocaine, anyone have any gut reaction? You don't feel like you should be here? Same question for illegal conveyance of drugs of abuse onto grounds of a specified government facility. All right, so everyone here in the courtroom today serves a different function. For example, my job is to represent the state of Ohio and to present evidence to you of the defendant's guilt. The court reporter's job is to take down everything that's being said here today. Your job is to decide the facts. The judge's job is to provide the law. And sometimes the law is not what you expect or what you think. Does anyone here watch CSI, listen to true crime podcasts, anything like that? Hands? Okay. If you've listened to number 2, if you've listened to a true crime podcast, well, what do you listen to or what do you watch?
I don't listen to podcasts. I watch like Law and Order, all those kind of things. I admit it. It came up earlier on the video, but I'm guilty of that.
Okay. And are there courtroom scenes in those shows?
Correct. Yes.
So you know that those are actors?
Correct.
Okay.
Yes.
So if I, have to shuffle my papers or stumble over my words, will you hold that against me? Same for Mr. Matthews.
That's very notable.
Anyone have a different answer to that question? Now, if you watch these shows or listen to these podcasts, whatever, and the law is different, maybe it takes place in a different state, different jurisdiction, are you able to apply the law that the judge has given you in this case?
Yes, I am. Yes.
Everyone else feels good about that?
It's really strictly for entertainment. I just like the show.
See, for us it feels like work, so we don't.
I don't look a lot into it, so.
Everyone have the same answer? If the law is different than what you think it should be, would anyone have trouble following it? So the facts are going to be testimony you hear from the witness stand, the evidence you're going to see broadcast here, there'll be physical evidence for you to touch. And after all that evidence is presented, that's when you get to make your decision. And that's going to be based on reason and common sense. Just based on your everyday experience, you apply it to those facts. It's also going to be your job to judge the credibility of witnesses. Again, you'll use your common sense and life experience to do that. Does anyone think they'll have difficulty determining if someone is credible or not? So as a state, we have the burden of proof. That's proof beyond a reasonable doubt. And we have to prove that the defendant is guilty beyond a reasonable doubt. And the defendant has no burden. The judge will give you an instruction about what that means. But does anyone have a preconceived notion of what beyond a reasonable doubt means? Does anyone think it means no doubt or beyond a shadow of a doubt? Do we all agree to listen to the judge's instruction on beyond a reasonable doubt? So every crime is made up of elements, and it's the state's job to prove those elements to you beyond a reasonable doubt. And if we don't prove one of those elements, you cannot find the defendant guilty. You have to prove every single one. Now the converse of that is that we only need to prove the elements. We don't have to prove motive. You might still have questions. If you have questions or just want to know more about the case, would anyone have trouble returning a guilty verdict even if all the elements were met? And can we all agree not to hold the state to a higher burden? We have a relatively short case for you today. I've listed the witnesses. And can we all agree that the quality of the evidence is more important than quantity? Can you hear something from one witness and be convinced of the truth? Do you think, would anyone here have trouble coming to a decision based on the testimony of just one person? Number 18?
Yeah, I don't think I can listen to one person give a statement because we don't know if he's 100% truthful.
Okay.
Whether he's on oath or not, so I think it's going to take more than one person as a witness.
And that's,
unless it's an extremely credible person.
all right, yeah, so that goes back to my credibility question.
Yeah.
Okay. So if you judge the person to be very credible, could that person convince you of what
Yeah,
the
if I was
person is
convinced
true?
the person was 100% credible, I could do that, but there's not too many people I can say are 100% credible. It's a thin list.
So if the witness you felt was not credible, you would not take into consideration what they were saying?
I would consider it, but would I believe it?
Okay, so you would weigh it appropriately?
I would have to weigh that, yes.
Using your reason and common sense? Number
I
one?
agree with that as well.
Okay, that's a good way to be. All right. Has anyone been convicted of any type of crime? Again, if you want to answer privately. Number 3?
Yeah, I've got a felony in possession.
Okay. In Lake County?
Yes.
From when?
2019-ish.
Did you go to trial?
No.
So you have an understanding of what the law is. Would you be able to put aside your knowledge about what the law is and your experience and be fair and impartial in this case?
Yes.
Anyone else? 16?
Misdemeanor,
Okay. Same questions. Would you be able to put aside your experience in your case and be fair and impartial here? 19?
Possession, like 2009.
Okay. Same questions. Oh, and sorry, you were shaking your head. Was that a yes?
Yes.
Okay. Can't see your number.
35.
35?
I had an issue in 1999. I'd rather speak privately.
Sure. That was 35.
35.
Anyone else? 11?
I have a misdemeanor in 2008 for disorderly conduct.
Okay. You'll be able to put your experience aside and be fair and impartial in this case?
Yeah.
Okay. So being a juror means you have to sit in judgment of another man. Again, you'll listen to the facts, you'll hear all the evidence, then you'll have to come to a decision whether the defendant is guilty or not guilty. Does anyone have any philosophical, moral, religious objection to sitting in judgment of another man? 30?
Absolutely.
Okay. What is that objection?
Private.
Sure. Anyone else? Does anyone have any friends or family or yourself that's in law enforcement? Police officer, like that? Oh, lots of hands. Okay, number 1.
Yeah, my brother's in law enforcement.
What kind?
He's a police officer.
Officer. Where does he work?
North Carolina.
Oh, okay. So do you see him often?
I do.
And do you talk about work with him?
Sometimes.
Would you be able to put aside whatever he tells you about work and just listen to the facts and the laws you hear here today?
Try.
You can try?
It's really hard. Like, I feel like I talk to him a lot. So.
Okay.
Yeah, but I would try this.
You recognize the law in North Carolina is different than Ohio? So you could try to put that aside?
Yeah, I can put aside the differences there.
With more hands. 2?
Yes, I have a cousin who's a East Lake police officer.
Okay. And do you talk with them about work?
He does. I try to avoid it, but he does talk, he likes to talk about it, so.
So same questions. Are you going to be able to put aside what he tells you about work and be fair and impartial in this case?
Absolutely, yes.
3?
My sister's able to be police officer.
Okay. Same kind of, do you talk about?
Rarely, yeah.
But, whatever you have talked about, will you be able to put that aside and be fair and impartial in this case?
Yes.
5?
I have a cousin who works in Timberlake and then he's a detective
Do you talk to them about work? No. Okay. Okay, end of my questions. 6?
I have an aunt who's a retired assistant prosecutor, I believe.
Okay, in Lake County?
Like,
Would you ever talk about work with her?
no,
Never talk about the law, anything like that?
not really.
7, did you have your hand up? No. 10?
I have a good friend who's a Lake County magistrate,
Okay. What kind of magistrate?
like family courts.
Okay,
They
do you-
did. We never talked. So, I mean,
Okay.
we see each other, actually have a monthly class dinner every month, so we talk, but we don't talk shop.
Gotcha. Are you gonna bring up your jury service next time you see them?
No.
Okay. You can, I just,
They know I'm going, but
Okay.
I won't talk about what we talked about.
9?
I have an uncle that's a Youngstown police officer.
Do you talk to him about his work?
Not too often, no.
But based on those conversations you've had, can you put those aside and be fair and impartial in this case?
Yes.
Anyone else here? 12?
Yeah, my dad was a police officer over in Shaker Heights for 30 years.
So I'm sure you talked to him about work.
Yeah, and my grandpa, my mom's dad, and then my mom's sister and her husband are both police officers, but they're retired too recently, so.
Would you talk to these people about their job, about work?
Yeah.
Can you put, what they said out of your mind and be fair and impartial? Back here, 32.
Yeah, I know 3 police officers, 2 in Lake County and 1 in Pittsburgh, Pennsylvania.
Do you talk to them about their work?
The 1 in Pittsburgh, yes, 2 in Lake County, no.
Do you discuss cases with them?
Just stories.
Okay. Can you put those stories aside if you are called as a juror? Anyone else? 34.
I have friends that are cops in the county.
Do you talk to them about their job?
Just a little bit, nothing in detail.
Talk about cases? But what you do talk to them about, you're able to set that aside and be fair and impartial in this case. Listen to the facts and the law. Anyone else? Oh, it's 15.
My uncle was a cop a long time ago when I was a kid.
Okay. Did you talk to him about work?
No, not really. I was probably about 7 years old.
You don't remember anything really? Does anyone have friends or family in corrections? Work at a jail, anything like that? 3?
My cousin does, Lake County Jail.
Lake County Jail, okay. We're gonna have some witnesses from the Lake County Jail. You talk to him about work. Will you be able to put your relationship with him aside and judge those witnesses in a fair and impartial way? Does anyone have any negative feelings towards police officers or law enforcement? You're not gonna hurt his feelings. 8?
Yeah, just like in any profession, there's an opportunity for dishonesty and, also just like speed traps and stuff like that can be negative.
Do you live in Willoughby Hills? So do you think you'd have trouble judging the credibility of a police officer?
I don't think so.
And you'd be able to be fair and impartial? Anyone else? Back here. Has, anyone have close friends or family that are attorneys? 6?
As I mentioned.
Okay, and we talked, you don't talk to her. Anyone else? 15?
Well, that's an attorney.
Did you talk to him about work?
I asked him how broad this season for my taxes.
Okay.
That's about it.
Does he do tax?
Yeah, he's more of a financial.
Okay, so not criminal law?
No, not at all.
That's a nice connection to have this time of year.
Yeah, my cousin really agrees.
Well, any of the tax knowledge or whatever else knowledge that you have gained from him, are you able to put that aside and follow the law in this case?
Sure, if you want to call it that knowledge.
Okay. 24?
Well, my brother's insurance.
What kind of law does he practice?
He has a law firm in Louis.
Does he talk about his work with you?
Never.
Oh, sorry, I forgot your number. 34.
My best friend's a defense attorney and guy with the county.
Okay. Do you talk to them about work?
Occasionally, yes.
And that's criminal defense?
Yes.
Do you discuss his cases, his clients?
Not just the cases, but about the clients themselves.
Will you be able to put what he says about work, about his cases aside, and be fair and impartial in this case? Follow the law as the judge gives it to you? Anyone else? So as you already know, this case is about cocaine. And the actual drugs will be in the courtroom. They'll be, wrapped in plastic. But does that make anyone uncomfortable? And without sharing details, again, I don't want to pry, has anyone here, either personal experience or a close family member, struggled with substance abuse? A lot of hands. One.
My older brother passed away from drug overdose.
Will hearing about drugs, testimony about drugs, will that affect you? Anyone else? 4.
My parents are addicts.
Will hearing testimony about drugs, will that, affect you?
No.
5.
My uncle was convicted of the drug charge.
Kind of the same question, hearing about the drugs, seeing, picture the drugs, the drug evidence, will that be hard for you? 10.
My brother went through rehab for cocaine and alcohol.
Was that successful ultimately?
Actually, it was. He lived 27 years in AA, so.
Same line of questioning, will that be difficult for you?
Yeah.
9.
Older brother, and then younger brother as well, who overdosed. That's what.
I'm sorry to hear that. So will it be difficult for you to be hearing about, cocaine? Appreciate that. Back here, I saw some hands. 16.
I had a cousin overdose.
Okay. Did they pass away? I apologize. Will it be difficult hearing about cocaine here today? 17.
Both parents were once addicts.
How are they doing today?
My mother passed away, but not anything related to that.
I apologize. Will it be difficult hearing about the drugs here today? I can't see your number.
36.
36.
I've got 3 family members. One currently still living. Started with addiction. They're deceased because of it.
Okay. Same question. Will you struggle? No. Oh, can't see your number. 22.
I have a couple family members convicted, but I was also just hit by a driver that was under the substance. I'm suing them right now.
Oh no!
Yeah, wasn't great.
When was that?
2 months ago.
In Lake County?
After it happened.
I'm sorry that happened to you. Are you physically okay?
Yeah, very lucky.
All right, well, good luck with that. Well, will it be difficult to hear about cocaine here today? Anyone else? Does anyone think that drug laws are too harsh or outdated? Right? 2026, I can put whatever I want in my body? Not really that extreme, but I saw some hands. Number?
35.
So you think that drug laws are outdated or too harsh?
I believe that it needs to be looked at a little differently and more, I guess, in the way of like helping the people as opposed to
Giving people treatment versus punishment. So would you be able to follow the law as the judge gives it to you and not, he handles the sentencing, what happens after? Would you have difficulty with that?
I don't think so.
Okay. Anyone else? You're going to hear from a crime lab analyst in this case. Did anyone know that we had a Lake County crime lab? Has anyone ever toured it? Does anyone know someone that works at the Lake County crime lab? Does anyone have any?
You got it.
Oh, sorry.
Back. 35.
35?
A number of years ago, I was with, he was actually a retired police officer, and his brother worked in forensics in the county. I don't know if he still works there.
Okay. Would you talk about his job with him?
No.
I don't have intimate knowledge of how the crime lab operates.
No.
Anyone else? Does anyone have any training or experience in drug chemistry, forensics? Now, I remember we had some nurses. Does anyone have experience or training in reading x-rays? 5?
I could read a basic X-ray.
Same for 6. So there's going to be testimony about an x-ray body scanner. Are you going to be, or how does that make you feel?
Yeah, same.
Do you think you would be harsh towards the technician, critical towards the technician?
No.
Anyone else? Experience with x-ray? And as you know, I think the judge touched on, and I touched on briefly, it's the role of the judge to worry about sentencing and what happens after this case. Does anyone think they would be too preoccupied or feel sympathetic towards the defendant and not be able to render a guilty verdict, even if the state proved its case? One moment, Your Honor. All right, before I end, any other comments about anything I brought up? Okay. Were there any topics I didn't bring up but you thought that I would? Okay. That's all.
Thank you, Mr. Matthews.
Thank you, Your Honor. Good morning again, ladies and gentlemen. My name is Jim Matthews, and I represent Mr. Burrell. Going last, a lot of the questions that I would have ordinarily asked have already been asked and answered, but I do have a few things that I do want to go through. You're going to be hearing a lot of testimony from police officers and corrections officers. Now, does anyone think that because of a police officer's or corrections officer's training, that they are inherently a more credible witness? Number
18.
Yes, sir.
I would think somebody that's trained in law enforcement and dealing with that should be a more credible witness.
Does that necessarily mean that they would be?
I would hope it would be. I wouldn't say it's 100%, but I would look at someone in law enforcement probably on a higher level of credibility.
Okay, now, in your instructions, if you are selected, the judge is going to instruct you that police officers, experts, lay people, no one's testimony means more than anyone else's. And if you were selected, would you be able to adhere to that instruction?
Yes.
Okay. Thank you. Does anyone think that police officers or corrections officers are less capable of making mistakes than an average person? Does anyone think that police officers, corrections officers possess superior powers of eyesight? And along that same line, do you think that police or corrections officers possess superior powers of recollection? Now, Mr. Burrell may not testify in this trial. That is his right, and if he chooses to stand on it, does anyone think they would have a problem finding him not guilty without having heard from him directly? Is that going to be an issue if that occurs for anyone? Now, Mr. Burrell has been indicted. He has been charged. And the judge went through what those charges were. Now, does anyone think that he must have done something wrong for it to have made it that far, for him to be on trial today? Does anyone feel that way? And does everyone understand that as Mr. Burrell sits here, he has the presumption of innocence? He is considered not guilty until, if, at some point in time, the state does prove his guilt beyond a reasonable doubt. Does anyone have a problem with that presumption of innocence? Does anyone think that the state is being asked too much to prove him guilty beyond a reasonable doubt? Now, for this question, I would appreciate a verbal answer. If the trial were to end right now, what would your verdict be?
Unknown.
Who said unknown? Juror number 10.
Yes, haven't heard anything yet.
Correct, but what is the presumption that we have at this point?
No presumption.
He is presumed to be not guilty as we sit here today.
Right.
So if the trial were to end right now, what would your verdict be?
He's presumed innocent until proven otherwise.
That be,
So that would be not guilty at this point.
thank you. Does anyone disagree with juror number 10? Now I want to talk a little bit about reasonable doubt. And the judge gave you the instruction, he's going to give it to you again, and we're going to talk about it later. But reasonable doubt is the highest standard of proof that we have in our system. We have people going to court and fighting about money. And in a civil case, a money case, the burden is 50.1%. You've got to, just over the line, think that, yeah, one person is liable. That's when we're talking about money. Now, we're talking about someone's freedom. So the standard is very, very different. Now, we can't put a number on it, but civil judgment is like this, beyond a reasonable doubt, far, far greater. Does anyone think that that is too much of a burden to put on the state? Now, at some point, if you are selected as a juror, you're going to take an oath. And does anyone have any doubt in their mind that that oath requires, this is not a suggestion, this oath requires and demands of you, that you acquit Mr. Burrell and find him not guilty unless the state proves each and every element of a charge beyond a reasonable doubt? Does anyone have a problem with that proposition and that burden that will be placed upon the state and that requirement that will be placed upon you? Nobody? All right. Very good. Thank you very much, Your Honor.
Thank you, Mr. Matthews. All right, ladies and gentlemen, at this point, you have been questioned by everybody that's going to question you, almost everybody. So what I'm going to do is excuse you guys. You can go out in the hallway, and you can talk about anything you'd like to talk about, except what we've just talked about for the past hour or so. Okay, that's off limits. Anything else is fine. The only thing I want to do, there are 3 individuals who I want to speak to individually. That's number 3, number 30, and number 35. What we'll do, everybody go out, and then we'll call each of you in individually, And then once the entire panel is called back, then we will identify those individuals who will serve as jurors in this trial, and the remainder will be excused. Okay, so go on out in the hallway and commiserate, and then we'll call you back probably we're looking probably around 20 minutes or so, okay? And then I'll have the bailiff come out and grab the individuals.
Thank you.
Yeah, I'm gonna cut it off right here. We will pick this back up again the next time Judge O'Donnell comes up. I want to welcome all the new I know that we had a new subscriber, and I'd like to welcome you to my channel. So welcome to the channel, welcome to my platform, and welcome to my family. And tomorrow is Judge Judge George Mertz. George Mertz. Yeah, Judge George Mertz is tomorrow's live stream. So I will see you. I will see you guys tomorrow at Judge Mertz's next live stream. Ta-ta and ciao-ciao for now. You all have a wonderful, wonderful evening, and I hope to see you really soon.